furthermore, as in looking at the final judgment, which you do have a copy of that one as well, I did submit that. And oddly enough, my portal was acting a little quirky on Thursday and Friday, so I couldn't submit it electronically, but I'm glad that the clerk did make it available for you. And also, I see that I made a filing on the 31st that didn't appear in the record today. Maybe it's just a matter of the court or the clerk updating the record. But if you go to your binder with the supplemental authority,
I don't have any binders, sir, but I have what's filed as docket entry 179, 125. I said 150, but it's 125 pages that were filed on March 28th. I'm not aware of anything filed March 31st. It may be too fresh and not imaged yet by the clerk for me to see.
Okay, very well. Go to Exhibit E, which is the final judgment, which is stamped March 1st, 2024, from the clerk. And when you get there, it'll probably be a little bit easier for you to pull it up than, I don't know. I think I gave it to Miss Scott as well. And Miss Britt should have it if it should be imputed to Miss Britt.
Right. I'm looking at the final judgment after a hearing held 10/3/02. It's got a rendition, a docket stamp date of October 17th, 2002. Yes, sir. What do you want me to be aware of here?
Okay, that final judgment does not have a child support guideline worksheet attached. And it is error for the trial court to decide the issue of child support without the benefit of a child support guidelines worksheet. And that's actually Florida Family Law Rules of Procedure 12.285, and that was J. And I subsequently attached the Durham versus DOR, which you can cite it at 850 SO2D 653, and that actually came out of the second DCA back in 2003.
Did you actually complain about that in your motion, the emergency motion?
I don't think I have to, but you're aware of it now. And actually, you would have had a duty, not necessarily you, but the attorney who pushed the case had a duty to inspect the docket before she proceeded. Now, whether it's just a simple issue of a 1983 issue, or if it's an abusive process, nevertheless, the rule is clear, and I'm pretty sure that Ms. McCarthy is aware as well.
When did that rule go into effect?
Doesn't matter when it went into effect. It was in effect in 2003.
Okay.
And unless you have some rule that would supersede what would have happened, but necessarily in 2003, then we're still where we are. And it still doesn't undo the fact that after the 120 days you didn't serve process. And that's been in effect since that's one of the bedrocks of American jurisprudence is jurisdiction.
Okay.
And then looking at the record, by the way, the case came out of North Carolina. Ms. McCarthy made a comment that Florida court had always had jurisdiction, and that's inside the transcript. Now, what I want Ms. McCarthy, because she made herself a witness, she testified to that when she said it. When did Monica Smallwood file a application for services in the state of Florida? Because I haven't been able to find that, and my request for production hasn't seemed to have produced that.